Just compensation. Definition of just compensation. The property's fair market value at the time of the filing of the complaint, or that sum of money which a person desirous to buy but not compelled to buy, and an owner willing but not compelled to sell, would agree on as price to the given and received therefore. National Power Corporation versus Baguio 2008. A full and fair equivalent of the property taken from the private owner by the expropriator. The measure is not the taker's gain but the owner's loss. Just compensation is intended to indemnify the owner fully for the loss he has sustained as a result of the expropriation. It shall be real, substantial, full, and ample, from the case of Republic versus Libunao 2009. Determination of just compensation. Determination of just compensation is a judicial function that cannot be usurped by any of the branch or official of the government, from the case of National Power Corporation versus Zabala 2013. No legislative enactments or executive issuances can prevent the courts from determining whether the right of the property owners to just compensation has been violated. Section 3A of RA number 6395, which limits its liability to easement fee of not more than 10% of the market value of the property traversed by its transmission lines, cannot restrict the constitutional power of the courts to determine just compensation. Statutes and executive issuances fixing or providing for the method of computing just compensation are not binding on courts, and at best are treated as mere guidelines in ascertaining the amount thereof. The general rule in computing for just compensation. Just compensation is computed at the time of the filing of the complaint for expropriation under Section 4, Rule 67 of the Rules of Court, whether the filing takes place before or at the same time as the taking or entry. When the taking of the property sought to be expropriated coincides with the commencement of the expropriation proceedings, or takes place subsequent to the filing of the complaint for eminent domain, the just compensation should be determined as of the date of the filing of the complaint. From the case of City of Iloilo versus Judge Contreras Bisana, 2010. Exception. When the property is taken before the filing of the complaint, assessment should be made as of the time of taking or entry. In cases where the fair market value of the property is difficult to ascertain, the court may use other just and equitable market methods of valuation in order to estimate the fair market value of the property, from the case of Republic versus Mupas, 2015. In order to determine just compensation, the trial court should first ascertain the market value of the property by considering the cost of acquisition, the current value of like properties, its actual or potential uses, and in the particular case of lands, their size, shape, location, and tax declarations thereon. The case of Republic versus Salvador, 2017. If, as a result of the expropriation, the remaining lot suffers an impairment or decrease in value, consequential damages may be awarded by the trial court, provided that the consequential benefits which may arise from the expropriation do not exceed said damages suffered by the owner of the property, from the case of Republic versus Salvador Supra. Prevailing rate of interest, 6% per annum, as per the case of BSPMB Circular Number 79 Series of 2013. What is the effect of delay? Generally, for non-payment, the remedy is the demand of payment of the fair market value of the property and not the recovery of the possession of expropriated lots. The case of Republic of the Philippines versus CA and the Reyes versus National Housing Authority. Exception. When the government fails to pay just compensation within 5 years from the finality of the judgment in expropriation proceedings, the owners concerned shall have the right to recover the possession of their property, from the case of Republic versus Vicente Lim, 2005. Abandonment of intended use and right of repurchase. If the expropriator or the government does not use the property for a public purpose, the property reverts to the owner in fee simple. From the case of Heirs of Moreno versus Mactan Cebu International Airport 2005. In Mactan Cebu International Airport Authority versus Tudtud 2008, the court held that the expropriation has the obligation to reconvey property expropriated but never used, on the condition that the landowners would return the just compensation they received plus the interest. Miscellaneous application. Taking under Social Justice Clause Agrarian Reform, Article 13, Section 4 of the 1987 Constitution. This provision is an exercise of the police power of the state through eminent domain, from the case of Association of Small Landowners versus Secretary of Agrarian Reform, 1989, as it is a means to regulate private property. When the state exercises the power of eminent domain in the implementation of its agrarian reform program, the constitutional provision which governs in Section 4, Article 10 of the Constitution. Notably, this provision also imposes upon the state the obligation of paying the landowner compensation for the land taken, even if it is for the government's agrarian reform purposes. From the case of Land Bank of the Philippines versus Honeycomb Farms Corporation, 2012. Taking also occurs when agricultural lands are voluntarily offered by a landowner and approved by the Presidential Agrarian Reform Council for coverage under Comprehensive Agrarian Reform Program covered through a stock distribution scheme. From the case of Hacienda Luisita Incorporated versus Presidential Agrarian Reform Council, 2012. Expropriation by local government units. What are the essential requisites for the exercise of eminent domain by an LGU? 1. Enactment of an ordinance, not a resolution. 2. Must be for a public purpose, public use, or welfare, or for the benefit of the poor and the landless. 3. Payment of just compensation. And 4. Must be preceded by a valid and definite offer made to the owner who rejects the same. The case of USI versus CA 2011.